Remember, anything you hear today should not be considered as legal advice. It is informational only. If you have any questions, always contact your association counsel for an opinion on official association business. With that said, I would like to now introduce, excuse me, one of our firm members from the Pompano Beach location of Kaye Rembaum, the famous Emily Gannon. Emily.
Oh, thanks, Jeff. Hey, guys. Now, Jeff, there was already a question. How do we get credit for this? Do you want to just reiterate that one more time?
Yeah. Yeah, Patrick, I'll reiterate one additional time that the way you'll get credit, we'll place a link into the chat later. You're going to click on that link. The evaluation will open up in a new tab on your browser. And that's how you will do that. I'll go over that process a little bit later, but please stay until the end to receive that link, or at least until we get to the Q&A. The required part is the content, the Q&A. We want you to stay, but that's the optional part. Lisa,
All right.
welcome. We're about to kick it off to Emily to get started.
Fantastic.
Hey, Lisa.
Good morning, Emily. Thank you so much for sharing your expertise and knowledge with us. We're so excited to have you. Not going to take any more time. My apologies for being tardy, but you're going to kill it. Thank you.
Thanks. Good to see you.
Yeah, you too.
All right, guys. So we'll jump into it. So let's see now. First challenge here. Let's see if I know how to use my Zoom properly and if I can share the screen with you. To give you a quick intro, I am, as Jeff said, from our Pompano Beach office. Our firm, as you know, this is all we do is community association work. So hopefully, you know, again, if you need an association attorney, you'd consider us. Jeff, are we good? Can you see the?
Yeah.
Okay.
Yeah, this looks good.
Okay, so we'll go through it, and again, I'm one of the partners here. I've been here for 12 years, something like that, practicing for 19. Oh my God, I know I aged
You
myself.
started when you were 10.
I know I was a child genius, guys. Let's pretend. Go with me on this. So this is all we do, all association work. Today we're going to be jumping into the present, how to update your governing documents and why it's important. As you may already be aware, if you're managers or board members now, you're probably aware that, you know, 2024, we had a lot of changes in the statutes. In the last couple of years, we've had a lot of changes to the statutes, really. So this is important to look at your governing documents and see what needs to be changed, either to comply with those things or to address sort of the changes in the statutes, things like that. What makes sense for your communities. But we'll get into it. So now hopefully you're in the right class. Hopefully you're interested in this. I know I already have heard from some managers and current clients. So hopefully I don't disappoint you guys tonight or today. I'll try and keep you entertained a little bit here. We are here only for an hour. It's a pretty quick class. We are going to touch on a lot of different topics basically by doing this. So if you have questions, please keep it to what we're really supposed to be talking about, amending your governing documents, even though we will get into some different items that would be in your governing documents. Please don't ask specific questions about your community. Keep it all hypothetical, general questions. Again, this is informational, not legal advice. Speak to your attorneys if you have questions. All right, so let's jump in. Okay, so like I said, we're talking about your governing documents and how to amend them and why we want to amend them. When I say governing documents, let's start simple. What are we even talking about? What are your governing documents? Now, it depends if we're talking about a condominium or if we're talking about an HOA. And we also could be talking about a co-op. Co-ops are also, also around. They're not as common, but we still have them. And South Florida has a lot of them, actually. So for co-ops, we'll sort of go off on a little tangent here. For co-ops, we're going to be talking about your proprietary lease, your bylaws, and then any rules and regulations you might have. Those are typically your governing documents in the world of co-ops. For condominiums, it's your declaration of condominium, your articles of incorporation, your bylaws, and your rules. In the world of HOAs, it's a declaration of covenants and restrictions, or declaration of covenants and easements, or declaration of easements, covenants, restrictions. Usually a variation of those words. Articles of incorporation, bylaws, and then your rules and regulations, any ARC guidelines, things like that. Now, we say them in that order because that is the hierarchy. If there's a conflict that's where we go. So we look at them in order of the deck, the articles, the bylaws, then any rules. Your rules may or may not be recorded. That's okay. They don't have to be. There was a time where the legislature sort of made a little goof with chapter 720, and in the world of HOAs, rules were supposed to be recorded. But so if that happened and you recorded some rules and now you want to amend them, I would suggest you record any amended ones, or you record something indicating that any future amendments are no longer being recorded, so that everybody's on notice. But generally, rules, regulations don't have to be recorded. The way you can remember this, there was apparently an old school commercial back in the day, and the slogan was "a little dab will do ya." So that's how you can remember declaration, articles, bylaws. Your declaration, whether it's condominium or of covenants and restrictions, your declaration is really what we consider your constitution. That's what contains most of your covenant restrictions. Anything involving, if you have age restrictions, if you're going to have architectural guidelines, if you're going to have lease restrictions, sale restrictions, all of those things should be in your declaration. That's the document that should have those items. It should address your assessments and whether you can lien for them. Those are the restrictions and the things that should be in your declaration. And that's, like we said, sort of your overall constitution. That's the agreement that you came into your community understanding the association is going to enforce certain restrictions. There's going to be whatever it is, certain age restrictions. I'm moving into a 55 and over. And then in exchange, you're making the same promises. I am over 55. I understand what I'm moving into. I'm not going to move in any small children, things like that. That's sort of the give and take of what your declaration has. Promises made between you as an owner and the association. Your articles of incorporation, that's what we file with the state. That essentially sets you up as a corporate entity, the association. So that's where you go to, sunbiz.org. That's all set up there. That typically just has, how many directors you're going to have, that kind of thing. Bylaws, that gets into a little bit more detail of how you're set up and sort of the government part of running your association and your organization. Notice requirements, meeting requirements, again, how many board members, if there's a restriction on the board members, whether they have to be owners or not, things like that. Typically those things are found in there. And then rules, regulations, and your architectural guidelines. Rules and regulations, keep in mind, those generally are adopted by the board. Not always. Sometimes if your documents require it, there may be a membership vote needed to change the rules or to adopt some new rules, or sometimes an option to sort of veto a new rule that the board has come up with. So when we say rules and regulations, we're sort of leaning towards the typical, these are adopted by the board. They're not approved necessarily by the membership, but check your governing documents, because that could not be the case. You might be one of those exceptions where the membership has to vote on a rule. That may be something going forward that you would want to take out of your governing documents and allow the board to adopt rules and regulations or to amend rules and regulations without the membership needing to vote on those things. Because again, as a practical matter, that just adds another step, that slows things down, complicates things. It's nice if the board can just adopt some rules, and you don't need the members involved. Now, we do get a question often about, okay, so we get it. Governing documents, we heard you, hierarchy, DAB, declaration, articles, bylaws, great. What about the statutes? Okay. I wish I had a nice clear-cut answer for you. We're going to get into it a little bit later on in a little more detail. But the question is always, so which one controls, statutes or our governing documents? And the answer everyone loves from a lawyer is, it depends. So Chapter 718 is the Condominium Act. Chapter 720 is your HOA Act, I suppose, Homeowners Association Act. 719 is the chapter that controls or governs over co-ops. Now, sometimes those chapters will have certain things in them that will apply, and sometimes it'll be what's in your governing documents that will control. And if those two things conflict, it can be it could be a clear-cut case of well, we follow the statute here, or it could be a case of we follow your governing documents here, but sometimes it's not so clear cut. And again, we'll get into that a little bit more down the road. The easiest example is when we talk about condominium elections. We get that question a lot. Our documents, our articles, our bylaws, whatever it is, lay out this whole process, and it's some notice and it's only one notice and whatever it might be. But in the world of condominiums, hopefully everybody knows, the statute is going to control on your election procedure, period. It does not matter what's in your governing documents, essentially, as to the election procedure. You are going to follow what's in 718 because it's a procedural thing. And again, we'll get into that a little bit more down the road, but that's the clearest example I can give you. If we have an election and we're in the world of condominiums, not HOAs, condominiums, it's going to be 2 notices, 60 days, envelopes, the whole process, and you're going to follow what the statute says. So again, we'll get into the whole statute governing documents question a little bit more, but let's keep going. All right. Next slide here. Oh, if I can do it. Nope, I skipped one. Nope. Okay, guys, I'm a mess. Amendment process. All right. So then the question is, all right, how do we do the amendments? How does this work? Is it easy? Is it difficult? Do we need members to vote? All of that. Important thing to note, and this was a recent decision. I say recent, but it was probably a couple years ago now, because again, ever since COVID, I have no concept of time. Florida case law says there is a 5-year statute of limitations on challenges to recorded amendments. So that means even if you have an amendment that you might think wasn't done properly, wasn't properly voted on, is, not exactly what the owners thought they were voting. If there's any reason that you might not like an amendment that you have in your governing documents, we'll say it that way. If it was recorded over 5 years ago, too bad, you're stuck with it. Can't challenge it. If it was last year and you don't think it was voted on properly or whatever it is, then we might have a reason to go back and challenge it and look into it. But if it's over 5 years, it's sort of locked in, it's in stone, you're done. Now, in theory, you could have another vote and you could change it that way, but you can't sort of void it just because you don't think it was done properly if we're over 5 years. So do amendments have to be voted on at a meeting or through written approval? Can you do it one way or the other? Now, most people are familiar with proxies. You guys hopefully are aware of what a proxy is. Essentially, it allows someone to vote for you. If you are the rightful owner and the voting representative or whoever it is, you can basically let your neighbor turn in your proxy. Your vote gets counted anyway, even if you don't come to the meeting. Now, in this case, if we're talking about amendments, that's something where you could use a limited proxy and you can actually list out, voting for or against proposed amendment number 1, proposed amendment number 2. Maybe it's a vote on, whatever it is, changing the leasing moratorium from 6 months to a year or whatever it may be. You can actually put your vote on that proxy. I vote for this amendment, and you can have someone else, like I said, turn it in, or you can mail it into management or mail it back to the board, and you get to express your vote and cast your vote, even if you are not physically at the meeting. It's a good tool. Now, obviously, proxy voting helps when we need to have a meeting and we need to get quorum and we need to get a vote and need to hit those numbers, because we know how it works. I know, and you're going to tell me this is the #1 complaint whenever I talk about amendments. What do we do because our owners don't participate? We just can't get people involved. We can't, it's impossible. I know, we hear it all the time. You are not alone on this. Now, unfortunately, I don't have a great solution for you, but there are things you can do. The proxy voting helps because you can sort of put some boots to the ground, so to speak. You can knock on doors. You can talk to your neighbors. You can try and get them involved. You can try and get them to sign a proxy, which is a lot easier to get people to do than to say, hey, next week, can you come to our meeting by the pool at 7 p.m.? Oh, no, I can't. My child has soccer, or whatever it is. Great. Could you just read this proxy form and sign it for me? That's much easier. Okay. But the first thing I'm going to tell you whenever we're talking about amendments, and this is sort of number one takeaway from today's class, period. The biggest tip is look at your voting threshold first. Before we get into details of various amendments, look at your voting threshold. If you are one of those older communities or you just have outdated language where it may say something like 75% of your owners need to approve an amendment to your declaration, then I understand why you're going to say, is this all, for naught? I'm not going to be able to get, we're not going to be able to get people to participate. We are never going to get 75%. We don't want to spend money on attorney's fees to draft all these great amendments if it's for nothing. And I understand that. And that's why I'm telling you, I don't want to take your money for nothing either. I don't want to draft amendments if they're not going to go anywhere. So look at your voting percentage first. Look at that threshold first. Start there. Step one, phase one might just be, okay, we have old language. It's 75% or maybe even 2/3. That's still pretty high. We're going to reduce that down. Our first amendment is just going to be to change the amendment provision. We're going to take 75% and reduce it to a majority, or we're going to take 2/3 and reduce it to a majority of those who vote at a meeting at which quorum is obtained. That's a much lower number than just a majority. Now, in our experience, typically you can get owners to understand a majority is still palatable. A majority of those who vote at a meeting at which quorum is obtained is still usually something members are okay with. Again, there's a little bit of, I see some paranoia sometimes with some owners where they think the boards are trying to pull a fast one and they want to reduce this because, what are they really trying to get to? So again, if you're concerned your owners might be a little suspicious, usually, again, a majority is an easy sales pitch, so to speak. A majority of our community is going to approve this change. So the board is, again, not trying to pull a fast one. Don't worry. Please approve this amendment to bring our amendment provision down to a majority of the community who has to approve the proposed amendment. Now look at all of your different governing documents, because if you're going to change the declaration, your declaration has an amendment provision, most likely. Then your bylaws have their own amendment provision, and your articles might have their own amendment provision. And they could all be different. It could be 75%, it could be 2/3 for your bylaws, and maybe your articles are amended just by a board vote. That's great if that's the case. Sometimes bylaws are amended just by a board vote. Also great if that's the case. Makes life a little bit easier for you guys. But that's going to be, again, number one takeaway from today. If you are at all thinking about amendments, look at your amendment provision first. If you have a high number and you need a higher threshold, that's going to be your largest obstacle. So start there. Step one, just have your attorney propose an amendment to reduce that down to a more attainable number. Again, a majority or a majority of those who are at a meeting who vote where quorum is obtained. So that was my big takeaway here. So let's assume now you've done that, or you have a number that's not crazy. You're already at a majority maybe. So we can move on to now what else? What else are we going to do? Or how else are we going to do this? So again, you want to look at some different amendments and how they're adopted in terms of potential grandfathering, so to speak, statutory grandfathering. That's what I like to call it. 718, 720, those two chapters. 718, that change has been in there for many years. 720, they added this only a couple years ago, that basically if you're putting in certain leasing restrictions, certain rental restrictions, potentially those are only going to apply to those who vote in favor of those amendments or those who take title after. They may not apply to your current owners who don't vote in favor, depending on what the restriction is. We won't get too much into it. And depending on some other factors, but those are things you need to be aware of, because again, if you're thinking, or if the board is thinking, we want to put these rental restrictions in place because we got to, shut down all these rentals we have. We want to really curb the rentals, get some more, owner involvement here. Maybe try and keep out some investors. These are the things we hear from lots of boards. Well, that's all well and good, but if you already have a whole bunch of investors in the community and a whole bunch of rentals in the community, you may have sort of lost control a little bit in terms of those guys aren't going to vote in favor of future lease restrictions, most likely. They're not going to vote in favor of, a leasing maximum or anything like their cap, because they want to keep leasing if they were investors. So you want to sort of get in and get those amendments in place before you have too many rentals or before you have too many investors. And this was the problem, and this is why those specific types of restrictions and those specific amendments have this sort of statutory influence as well. Any other type of amendment, generally, you're fine. There's no statutory implication. You can amend your declaration for almost any purpose, as long as it's not something that's, basically offensive to public policy or not constitutionally, appropriate, things like that. But anything else essentially is fair game. But the leasing restrictions, we have to be careful. You have to look at the statute. You have to see if those are things that are only going to apply to those who take title after, because again, depending on what you're trying to do, that may impact whether or not that amendment really makes sense for you. Now, voting rights, suspension of voting rights, that's another important factor. You have to keep in mind, if you suspend voting rights, which can be done for certain purposes, delinquencies, things like that, that may change your entire calculation of how many, what numbers you need for quorum, what numbers you need to get the amendment passed. So you may want to look at whether or not you're doing that. Typically, if you suspend someone's voting right, it's because they're delinquent. And if they're delinquent, typically they're not really participating in association stuff, and they're probably not going to vote anyway. So keep that in mind. Talk to your attorneys about whether or not that's a good idea for you. You want to look at, again, if you're doing this at a meeting or if you're doing it through a mail out, a meeting, you can use those proxies, like we said, and then those proxies, keep in mind, are going to be good for 90 days. They don't expire until 90 days after the date of the meeting for which they were originally given. So you have some wiggle room there. You have a window of time. If you call the meeting and you get some proxies and you get some people to show up, but you don't quite hit your number and you don't get, the vote you needed, then you could reconvene the meeting maybe 2 weeks later, maybe 30 days later. As long as you're within that 90-day window, those first proxies that you got for the meeting, those are still good, those still count. And you can gather more, you can knock on doors, you can send email blasts, all of those things. A new wrinkle or a new variation of this whole thing in the last couple of years, online voting, electronic voting, that has helped a lot. Now, obviously, since COVID, online voting has become a lot more popular. It had been around just recently before COVID, but then really COVID really helped it take off. So I know we said some of the sponsors here tonight, Vote HOA Now, ONR. Those are some companies that will help you if you're interested in online voting. There are some others. You can look for platforms. Bottom line, you're going to need a platform to do that for you. You can't just say, hey, we're going to let our owners, send in an email. Not how it works. You do have to set it up the right way. The statute outlines how to do it. There's an administrative process. The board has to have a special meeting. It's a 14-day notice for that meeting. They have to basically adopt a resolution saying we're going to allow electronic voting. They have to have chosen their platform at that point, which is going to have certain safeguards in place, making sure those meetings or those votes are anonymous, but also tracking them so that we know, Mr. Jones in Unit 101 only gets one vote. So we got to make sure Mr. Jones doesn't vote 5 times. So there is a way to do that with their system where they can track that Mr. Jones only voted once, and the system will know that Mr. Jones voted in favor of the amendment, but we won't know by looking at the results. Oh, Mr. Jones voted, that sort of thing. So online voting is a helpful tool. It's not very expensive. Again, I think now that it's become more popular, there are more platforms. Look into it. That could be something that helps you get these votes going. That's another suggestion for you.
Hey, if Ruth had a question, can electronic voting also be used for an amendment? I think you just touched upon that.
Yes.
So it could be the entire thing or just an amendment, correct? And
Yes.
do you still need a proxy if you do that?
So the way they do it a little differently, because it's not quite the same as voting in an election, but yes, you can use it online voting. Talk to, whoever your vendor is, whatever the platform is. They set it up again a little differently. And depending on what sort of arrangement you have, I know some of the companies do, you know, you can sort of buy a package where they only handle your annual meeting, or
Right.
they handle X number of votes for you for a year. So that can include these amendments and that sort of thing. So you can talk to the platform that you look into, but it's definitely an option. Yeah. For
Absolutely. Yeah.
amendments. Yeah. Anything you can vote on, you could do through the electronic voting.
Cool. So
Yeah.
folks, if you are interested in that, when you fill out the evaluation later, we'll place the link into the chat a little bit later. So Emily, have a drink of water for a quick second. If you don't see your chat area now, click the chat button so the area shows up. It'll say disabled because you cannot chat with us, but we can send stuff to you. You should be using the Q&A for your questions and answers. So hit the chat button now if you don't see the chat area. And once we put the link there and you click on it later, one of the options is to receive information from our partners who help make today's program complimentary, the entire series complimentary. And the two providers that Emily mentioned earlier are on that evaluation. So if you'd like to learn more about online voting and other things that it can offer, click them and anybody else you'd like to hear from. Back to you. I'll be back towards the end once again.
Okay, cool. All right. Another thing to just be aware of, and then we'll sort of get into the meat and potatoes here. If we're talking about, and this is why we have material amendments, things like that. Well, two things I guess I should touch on very quickly. If you are talking about any sort of vote on material alterations, that might be something, and we'll get into it more, that has a different sort of approval voting process. So look at that as well, because you might want that to sync up with your amendment procedure or your amendment threshold. Make sure those are the same, just to make life a little bit easier again. If you're in a condominium and if there's any discussion or thought of changing the percentage of common elements, of ownership of the common elements and percentage that you pay for common expenses, all of that, that is something specifically that the statute says cannot be changed unless you have the approval of 100% of your owners. That is the only one, and you're not going to be able to change that, essentially. So again, it's rare. Why would you be changing sort of the common element percentage or any of that? It is rare, but that's something to be aware of too, because it comes up every now and again, and that complicates things. And essentially, again, not going to be able to change it. 100% of your owners, and then typically their mortgagee approval as well. But again, probably not something you're really going to encounter, but something you wouldn't be able to change. All right, so let's jump into some of these. True or false? We're going to go through some kind of the hits, so to speak. What provisions are illegal? What's holding you back or costing you money? Now, I know we had a question before this even started. It came in yesterday. Someone said, our docs have never been amended. Basically, it's been smooth sailing for 20, 30 years. So why should we think about amending our documents? Seems like we're pretty good. And to that gentleman, I say, lucky you. That's great. I'm thumbs up. Couldn't be happier. But still, even with that being said, that's been smooth sailing, things are going well, we don't really have issues in the community, you still might want to look at amending your governing documents, because you may have language in there that is either basically illegal or going to expose you to some sort of discrimination claim, or that's costing you money. And why, again, I don't gamble, but why leave money on the table, as they say? So let's get into some of these. All right. First hypothetical: if foreclosing lender is required to pay 1% of the original mortgage debt or 12 months of delinquent assessments. Now, we write these in a way where it's supposed to sort of be throw you a little bit for a loop, where you hear that and you go, yeah, that sounds good. That sounds right. That's what I've heard. Safe harbor, whatever. Well, technically, false. Okay. So you may have heard of safe harbor, and that is typically a first mortgage lender that forecloses is probably responsible for the lesser of the 1% of the original mortgage debt or 12 months of delinquent assessments. Obviously, once they take title, they're responsible for everything going forward after that. But they get that privilege and that protection of safe harbor. That's what we call it. Usually, typically, generally. However, you need to look at your governing documents, because your governing documents might have language that's actually more restrictive than that. That safe harbor provision was put in the statute however many years ago. And if your governing documents have language that say, nope, a first mortgage holder that forecloses owes nothing, which that could be the case, owes nothing. So you're, Mr. Smith, who didn't pay for years and years and years, and you're sitting around waiting for Bank of America to complete their foreclosure because Mr. Smith hasn't paid, and you want Bank of America to finish their foreclosure on Mr. Smith. And they foreclose, and Bank of America, then the board says, great, Bank of America took title. Can we tell them that Mr. Smith owed us $40,000? No, you can't, because Bank of America doesn't owe you the $40,000. Bank of America might owe you the lesser of the 1% or the 12 months, or depending on your governing documents, Bank of America might owe you nothing and just the amounts going forward. So we need to look at that. If your governing documents have that language that puts you in a worse position than the statute, maybe we want to address that. Maybe we want to amend that. Maybe we want you to be getting more money and recovering more. So that's something that you definitely want to look at. That's an easy amendment, and that's something your owner should definitely support. That's usually a sort of an easy one. We start off nice and easy here. Your owners are going to support it. Go ahead. Easy amendment there. All right. Next one. All owners must go through the screening process in our community. Now, full disclaimer, we're already at 11:33. We have a class on screening and the whole sales approval, tenant approval process where we talk about just that for a solid hour. I'm going to keep us to a fairly quick pace here. This is a hot topic. This is something that we could talk about for a solid hour, but we're just going to hit the highlights here today. So first things first, again, it's false. Bottom line is, this is a document-specific question. And when I say that, that means it is specific to your governing documents. The answer is maybe. All new owners go through the screening process? Maybe. Maybe that's what your governing documents say, or maybe they don't. And you want to look at that and you want to see, okay, do we actually have the authority that we think we have? Do we have the authority that we want to have? Do we need to change this? Do our documents only say we can review sales and leases, but they don't actually address any quitclaim deeds or gifts or devises or inheritances? What about occupants? What about guests? Do we screen those people? Do you have that laid out in your governing documents as well? What if, and then we go into this too, what if it exempts certain parties, spouses, children, things like that? We see it in a lot of these 55 and over or 55 or better communities, that sometimes there are exceptions for an inheritance or a transfer that's interfamilial. And that makes sense. I understand why those are there. You want owners to be able to pass their property along to their children or to family members. But I've also seen it from the other side, where those same exceptions are in there, and then you have an adult son who has a terrible criminal history or lived in the community at one point and was a terrible problem. He got into, arguments with everybody. He never followed the rules, all of these things. And now if you have an exception like that, maybe he's a new owner. His mom passed away and he's now stuck in the unit, and there's nothing we can do because we have no authority to screen him, essentially. So, we see both sides of this, and you want to make sure whatever language is in your governing documents is the language you want in your community and that makes sense for your community. Now, again, maybe you don't care and you'd like those exceptions. Great. Or maybe you want to be able to screen everybody. Great. Totally up to what, suits your community. The important thing to know too is if you are going to be screening, if you're going to be reviewing sales, you have to make sure you have the right language in your governing documents. If you are going to disapprove a sale, you have to have the right of first refusal also put into your governing documents. Those two things go together. The ability to disapprove a sale and the right of first refusal. Now, we won't get into it too much. Hopefully you guys are sort of familiar with that phrase. Essentially, it means if you're going to deny a sale, the association has the right of first refusal. So the association could could step in or provide a substitute purchaser who will purchase that unit or purchase that lot with under the same terms, same amount, all of that good stuff. So that your seller owner is not damaged in any way. Okay. Seems logical. Now, the way around that, where people say, well, we don't want to exercise the right of first refusal. We don't want to buy the lot, or we don't want to buy the unit. We don't want the association to have to take that on, but we want to disapprove this because we don't like the applicant because of XYZ. Now, if you have certain authority, you can still do that without having to exercise the right of first refusal. So if that applicant doesn't meet the criteria in your governing documents, essentially. So, and some of them are clear cut. Well, you know, we're a 55 and over community, and these applicants maybe didn't realize or whatever it is, but they don't have someone who's going to be a permanent occupant who's at least 55. The application reflects, you know, it's a husband and wife who are 30 and they have 2 small children. Well, then clearly they're not going to comply with the governing documents. So you can't approve them moving in. That doesn't make sense. You can't approve that sale. Now, that's a nice clear-cut answer or a clear-cut example. They're not also clear-cut. So if we're talking about, you know, not complying with the covenants and restrictions of the community, we want to make sure you have that criteria in your governing documents so you know what you're evaluating these applications based on, and when you have the authority to disapprove if you want to disapprove. That can get very complicated when we're talking about looking at criminal history. It can get complicated when we're talking about finances. You know, can we disapprove based on a credit score? We get that question a lot. These are all things that could be factors that you're looking at. But again, it depends on the authority in your governing documents. It depends on if you have some criteria adopted. All of these things could factor in. And also, I warn you, really look at your governing documents, see what your process has been. I've had a community that told me they were, you know, screening applicants for years. And this was the first time they wanted to disapprove somebody. So they weren't sure how to do it, but they'd been running background checks. They'd been running, you know, credit history. They'd been doing this for years. And then I looked at their governing documents and I said, hey, guess what, guys? You actually don't have the authority to do that. You could have had somebody complain this whole time that you're, you know, improperly running their credit history, improperly running background checks. You don't have the authority. It's not in your governing documents. That's something though now that could be amended in and put in, and there you go. Now you want to look at, like I said, make sure the authority you have is the authority you want and that it covers everything. Quitclaim deeds, inheritances, all of those things. Look at, again, do you screen occupants? What about guests? Is a guest who stays in the community over 60 days? Do we consider them like an occupant? Do we screen them? Or is a guest just totally immune? And obviously we know how the games that are played where someone says, oh, that's my cousin. I'm not renting. It's my cousin who will be in town for 6 months. And by the way, I'm not there. They're staying there for 6 months. I get it. If you have lease restrictions, we see those games all the time. But if you have these restrictions, in theory, it doesn't matter. You still would get to screen that person if you have that language in your governing documents. So look at what's in your governing documents, make sure it matches what you want to do and what makes sense for your community. Keep in mind too, and this is a small detail, but if you charge a transfer fee for the screening process, basically for an application, something like that, there is a limit in the statute under 718. So for condominiums, you're limited, your hands are tied. The statute says what it says and you're stuck. $150. They did increase it last year. $150 per applicant. Husband and wife are considered one. Dependent, parent dependent is considered one. And that's it. There's no limit for HOAs. So you're free to charge, whatever application fee you want. You can charge capital contributions if you want. You're okay there. But condos, the statute limits it. So you want to make sure, check your documents to see that you are entitled to charge transfer fee, and then maybe adjust it if it has old language. If it says something like you can charge a transfer fee of $50, maybe you want to change it to in an amount, the highest amount allowable by law. And then as that changes, you can change it too. All right. This brings us to, once the law changes, the change is automatically applicable to your community, true or false. Okay, like I said, complicated issue, but basically there are some times where the law is going to apply, the statute is going to change, and you're going to be stuck with the new statute, or there are some examples where the statute's going to change and it doesn't matter and you follow your governing documents anyway. This is not a clear-cut issue, and this has come up much, much, much more frequently in the last couple of years because of all the recent changes to the statutes. You're going to hear the terms Kaufman language. That's from a case. Basically, if your documents are submitted to the statute either frozen in time when your declaration was recorded, maybe in 1999, you might have the benefit of Chapter 718 or Chapter 720 as it was in 1999, and you might be allowed to sort of stay there. If you have Kaufman language, which is also beneficial for certain other reasons, then that would say basically you're subject to 718 or 720 as it's amended from time to time. That's the key language, as amended from time to time, meaning you're no longer stuck in the 1999 version of those statutes. As the law changes, your declaration changes with those laws, with the statute changing. Beneficial because you don't have to amend your declaration every time the statute changes, but sometimes not beneficial depending on the changes in the statute. Now, there's another aspect to this. If there is a procedural or remedial change to the statute, so like I said, the election provision that went into effect for condominiums, that's a procedural change. You're stuck with that no matter what your documents say. That's how it is. If there is a fundamental contract right, if there is a substantive change to the statute and there's a fundamental contract right, that's where that analysis of do we have Kaufman language, do we not, comes into play. And are we subject to the changes in the statute or are we not? The most recent one is with the Chapter 720 with some changes about, fining for garbage cans and allowing commercial vehicles to be parked in driveways. Now, we won't get into all of that. That's the recent stuff. You want to make sure you follow up on that. But that is one of the new sort of hot topics is, does that apply to us? We have commercial vehicle restrictions. Does this mean now we have to let people park their commercial vehicles in the driveways? And the answer is maybe, depending on the language in your governing documents. Or again, depending on whether we consider that a fundamental contract right. Arguably, maybe that change in the statute doesn't apply to your community. But again, legal argument, talk to your attorneys. It gets very complicated. All right. Material alterations. This is another hot topic. Board must obtain a vote of the owners before making any material alterations. False. Again, look at your governing documents. I know I sound like a broken record, but your governing documents, if you're in the world of condominiums, the statute essentially says if you don't have language in there, then it's going to be a 75% vote. If your language is something else, then you follow what's already in your governing documents. So you might have something in there that says only 2/3 or only a majority or whatever it may be. So maybe you're not stuck with the 75%. Or it may be something where there's sort of a distinguishing factor of you only need a membership vote if that material alteration is going to cost more than $10,000 or more than 10% of your budget, or something where there's a qualifying piece of the puzzle. And then great, if it doesn't hit that threshold, then it's just a board vote. You don't need the owners to vote. Okay. Now, again, there are also some exceptions to that. When we talk about material alterations, typically this is a condo thing. It's not usually an HOA thing, but it has to do with any change to the common elements that is, palpably or perceptively made, that changes the function, changes the appearance, all of those things. That definition is not great, I'll be honest, but that's what we're stuck with, something along those lines. So figuring out whether something is a material alteration is step one, and sometimes that's complicated. Now, there's exceptions for necessary maintenance items. That's the other complication here. The case that we all talk about is the seawall case. You'll hear us say the seawall case. And in that case, board had to repair a seawall. As I'm sure you guys know, repairs to seawalls, very expensive. Of course, there was an assessment that was part of that, and there was an owner who said, I don't want to pay that assessment because the board was supposed to get a membership vote. I don't think it's proper. Excuse me, shouldn't have to pay it. Now, okay, went through the channels, through the courts, and luckily the overall verdict was, and thank goodness, because this was actually a logical, nice conclusion here. If it is a material, if it is a necessary change, if that material alteration is a necessary maintenance item, a necessary repair, which again, fixing a seawall, that could not be more obvious. You need to fix a seawall, or, you know, the building could crumble into the Coastal. So that was a nice clear-cut example. So if it's a necessary maintenance item, even if your documents say you need a membership vote, or even if the statute would otherwise require a membership vote, you don't need a membership vote. Further, the board has to do that repair. The board not only doesn't need the membership vote, but has to do the repair, not even doesn't need to get the membership vote, shouldn't bother basically with the membership vote, because they have to do it. If it is something that is a necessary repair, necessary maintenance item to the common elements, and the board is responsible to maintain the common elements, so they have to do it, or the association is. So the board has to do it and has to make that choice. They don't have to get the vote, shouldn't get the vote, don't bother with the vote, you're good. But now again, that's a limited exception. It has to be necessary maintenance. If you're gonna try and say we didn't need a vote because it's necessary maintenance, then make sure you have the support for that, that you have a, you know, an engineer's report or an expert's report that says this one item needed to be repaired or replaced or fixed ASAP, or whatever it was, or there could be severe damage or whatever it may be. But make sure you have your expert opinion to back that up. Again, limited exception, but still a very helpful exception. HOAs, usually it's a little different. Typically it says something like a limit on capital improvements. Usually it has to do with, again, if it's 10% of the budget or whatever. You may want to change. So look at these provisions in your governing documents, because you may want to change them, because, you know, maybe again, if you have the old language, or if you have still 75% or whatever it is, and you're going to be doing some repairs, you're going to be doing some renovations, you're going to be making some changes, and something could be considered a material alteration, and you know you're going to have to get those votes. Think about it now, change that voting threshold. Same kind of thing we started with here. Look at that provision, change that provision before you start doing any of these projects, make life a little bit easier for you. All right. Delinquent assessments accrue interest at the rate of 18%, and a $25 late fee applies. Again, sounds right, because that's the basic gist, but not necessarily. Again, to charge a late fee, that has to be in your deck or your bylaws. If you're going to assess for it, it has to be in your deck and lien for it. For condos, interest can be charged at the rate provided in your deck. So you may actually be losing money if you have old language that limits your interest rate to 9%, 10%. Great. You could be going up to 18% if your language in your declaration allowed you to. So again, why leave money on the table? Change that, amend that, allow the association to actually get the 18%. For HOAs, same thing. You can be charged interest as it's provided in your deck or in your bylaws. If there's no rate, it's the 18%. But those are things that if you don't have the authority for interest or late fees, again, you're just losing money. So that's an easy amendment. Put that in there, get your interest, get your late fees, make sure you're getting the maximum that you can do. All right, this one's a tricky one. If there's a pipe in a wall that only provides service to one unit, that unit owner is responsible for the maintenance, true or false? Hopefully you guys know, sometimes that's true, sometimes that's false. It's really, and the tricky part of this is, and this obviously is for condominiums, but the boundaries of your unit, your maintenance requirements, and this throws people off, but this is how it is. There's nothing in the statute that says necessarily association maintains X, owners maintain Y. That's not in the statute. It's going to be in your governing documents. Your maintenance obligations are in your governing documents. So if you want to make sure those are nice and clear, and maybe again, your governing documents, keep in mind, are drafted by the developer. They're not in your community anymore. They put this together when they were building it. They wanted to encourage, lending. They wanted owners to, or they wanted banks to come in. And other than that, they didn't have much skin in the game. They wanted to sell the units and they're out. So they don't necessarily have all the best language all the time. These decks were usually drafted years ago. They may not address, well, is that a common element pipe, but it's a common element pipe that only serves one unit. So maybe just that one unit owner should be responsible for it. All of these variations, if it's just within the unit, if it's within the common elements, those boundaries are going to be what's written in your governing documents. Sometimes balconies are considered part of the unit. Sometimes they're not. Sometimes they're part of the common elements. Sometimes they're a limited common element. It all will depend on what's in your governing documents. So you want to make sure certain maintenance things may have come up in the last couple of years and it's not clear. Is that an association thing? Is that an owner thing? Who's responsible? Pipes, we see it with a lot. AC lines, depending on where your ACs are located and where the compressors are and condensers are and all of that. We see that a lot. There are questions. It goes up to the roof, whatever. Your governing documents can address all of that. You can amend your governing documents to provide that the association is responsible for X, owners are responsible for Y. And you can have variations within that. You can say the association is going to be the one that does the repair, and owner is actually going to be the one responsible for the cost of it. You could do that too. So it sort of splits the difference. Association takes it on because maybe it's within the common elements, and we don't want unit owners having contractors go within, go into the common elements. So we'll take it on, but we're going to charge it back to that unit owner because it was his pipe or his AC line or something like that. All of that can be however you want to word it in your governing documents. All right. So we got through it all. We made it in under an hour. Do some highlights here. Again, key points. Again, I'm going to tell you, check your threshold, your voting threshold to start with. That's step one. Do that before you do any other amendments. Because again, I don't want to take all your money and spend all the time doing amendments if they're not going to go anywhere. Safe harbor, look at that. Look at your mortgagee liability. That's an easy amendment. We don't want to leave money on the table. And then interest late fees, same thing. Easy thing. We don't want to leave money on the table. Old language, new laws, all of that. Kaufman language. You want to talk to your attorneys, see if that's something you have, see if that affects, again, these changes in the statutes, if those affect you, or if you want them there, you don't want them there. Maybe you want to change that language depending on, again, some of those changes. So those are the highlights. And I think we made it through. Do we have some questions?
Excellent.
You did.
There are
Yes,
some.
Go ahead, Jeff.
I'm just going to mention there are some questions, Emily, and if you and Lisa want to go over look at the questions while I go over the evaluation process really quickly with everybody, let's do that. So take a look at some of the questions. And folks, I will say there are 220 something of you and a lot of questions. We're not going to get to all of them. We'll get to a few of them. So ladies, please look over the questions and I'll go over the evaluation right now. So folks, in the chat area, I placed the link for the evaluation. When you click on that link, it's going to open up a new tab in your browser and takes you here. Okay, this is what you fill out. Please follow the directions. This is what you need to do to cross-check that you were here for the entire time, or at least until we placed it into the chat a little bit earlier. And for those of you asking for contact from some of our providers, including the voting and software companies, it's question 10 where you click, hopefully you want to get contact from everybody. But for those of you asking about the online applications, Emily earlier mentioned Vote HOA Now and ONR applications. Check those boxes. They'll get these reports for those of you asking for contact, and they'll get in touch with you. So after you fill out that evaluation, and bear with me, I'm working with one monitor today. It's difficult for me. You hit the submit button and then the confirmation screen. For those of you asking about slides on certificates, this is where you can click to get the slides right over there. And this is where you click to get your certificate. You can print them and save each one of them. Emily's contact information, our next ACE webinar, the Kaye Rembaum website right there, and the ACE by TSK website right there. So after submitting the evaluation, this is the screen you hopefully see, and that's where you can get everything that you have all been asking for. So ladies, I'll turn it back over to the both of you for the Q&A portion.
Yeah, there are a couple of things I just wanted that I see in here that we should address. Quick question, do we have to amend the docs to allow online voting? No, so that's not a document change. That is something though that has to be done properly. There's a procedure in place. It's a board meeting, 14-day notice, a resolution has to be adopted, then a certain notification needs to go out to all your owners, but it's not an amendment to your declaration. So but talk to your attorneys because it's not necessarily a very simple process. There's a little bit of a procedure, so you want to make sure you do it right. Someone does say, can electronic voting be used by owners who live overseas? That's the benefit. They could be anywhere as long as they can log in, basically. So great. And they can do it through the app too, and, you know, on their phone. So wherever they need to be.
Yeah, the most important thing about overseas stuff is just mind your time zones when you're sending out emails and information. Just just make sure that, I don't know how all of these applications work, but you want to check to make sure that all the time zones are enabled so that everybody who's supposed to be getting them gets them. And Emily, correct me if I'm wrong, as I do not have an ESQ after my name, that everything that anybody opts into, whether it's online voting or emails from an association, it is up to the owner to be sure they're able to get those emails. So if stuff ends up in the spam folder or the junk folder, it's not the responsibility of the association or the association's council. You have to make sure you are able to see those emails, correct?
Correct. And that's why they want you to set it up with enough in advance so that owners can make sure that their system works and it you know, corresponds. But yes, and that makes sense. The association can't be responsible for everyone's, you know, spam folders. So, you know, once you give us an email address, that is the email address we will use, and then it is on you to make sure you actually are receiving the notifications. And some
Emily,
use a combination of online and paper voting. And yes, ultimately that's probably what you're going to do, because it's rare that you get an entire community to actually participate in online voting. Sometimes I've seen one where there was one owner holdout who voted by paper, and then that made the fact that their vote was anonymous a little awkward, but but hey, if you get everyone to do it, great. But otherwise you are going to end up doing sort of both. Yeah.
And Lisa, I know you had a question. Somebody texted you, and did you have a question, Lisa? That you wanted to...
somebody asked if there's a template or a best practices process for a board to use before they engage the attorney to revise docs. And I thought that was a great question.
It is a good question. I don't have a form. Essentially, it's sort of, this class is what we hit on, sort of the key points of what we see that are the most common issues that most communities have. So that's where I would tell you, look at those topics that we touched on today, and look at your governing documents and start there. And someone also asked about the process of doing the amendments and proposing them and all of that. And that's important too, because again, the board can try and minimize it. Again, it's going to be, it's not a cheap process if we're talking about redoing your governing documents, top to bottom. It takes attorney time. It just does. That's part of the deal. If you want to minimize that, great. If you can set up committees, if you can have the board go through the documents first and really highlight the key points or, key issues, go through the opinions you've had from council over the last couple of years. Have they told you, hey, this is something you can't do, but you could if you had an amendment, or, this is something we can't enforce unless you guys amend your documents. Go back through those opinions and put a list together. Okay, these were the things that we really think we should be changing and we should be looking at. And you can do it in a different way. You can do it, sort of piecemeal, whatever key topics are pertinent for your community. You could do it a la carte, so to speak, and do a couple amendments at a time, or you could do an entire rewrite, whatever makes the most sense for your community. Some people say, well, we don't want to spend the money to do a whole project now. We just need these couple things we need to get, in place. And that's fine. And you could do it any way you want. It's really up to the board to sort of drive this ship here. And you can present it the same way. You can present them. Someone said, is a vote, all or nothing kind of thing. No, you could present them as, here's a proposed, list of 10 amendments, and you're voting for or against 1 through 10. Or you can do an entire restated declaration and you're voting for or against just the restated declaration. Whichever way makes sense for you guys, whatever, works for your community. If you're going to do it with a whole restated deck, which obviously there's a little bit of risk because it's an all or nothing vote, maybe you want to have your community really involved. I would tell you, have some town halls, do some question and answer sessions, talk to your owners, have the attorney come out and go through it with your owners. And that's usually the way to sort of get the support, but up to you. It's really however the board wants to do it.
Now, granted, where I managed in the past, we had the budget of a small city. So it's not an apples to oranges, an apples to
Right.
apples comparison. But I will say one of the lessons I've learned, which Emily indirectly alluded to, trying to do more for less now can create more of a mess and more money later. So you want to do the best you can to do it right the first time, even if it's going to cost you a little more than what you
Right.
hoped, but it may save you a lot more down the road, you know. Do you have time for one more? I know it's a little bit open. Because this came up a few times in the Q&A, somebody asking about material alterations. There's more than one question in here. So here's one example. And again, I don't have ESQ after my name, so I'm going to answer this. And Emily, I'm going to see if you think I'm right or wrong. Okay.
Okay.
Are tennis court repairs in an HOA considered necessary material alteration? Can you elaborate a little more on what is considered necessary material alteration? So what I would say, if I had an ESQ after my name, and you're going to tell me if I'm right or wrong, a repair is not a material alteration. A material alteration would be if you're converting, let's say, from tennis court to pickleball.
Right. And I would agree with you. Essentially, it turns into if it's a repair or if it's now again, if it's a repair with a certain change, if you're saying, well, we're repairing the tennis courts, but we're changing out the whatever it is, 5-foot black chain link fence, and we're putting up 10-foot tall whatever fencing.
Yeah.
And now you've changed the appearance of it, and it's not really a, again, sort of apples to apples
Gauging its use, right?
change. So that could be something that now becomes a material alteration, even though it was a repair as well. But if it's again, a necessary repair, really, that's where I'm saying don't use that exception, haphazardly. Talk to your experts. If it's a situation, and think of the example. The example was a crumbling seawall. So that's the level of sort of importance we're working from there.
Right.
It's not just, again, we needed to fix this, so we put in completely different flooring and we upgraded to marble instead of the tile we had in the lobby. But the tile was old and it needed to be fixed, so we put in marble. You're going to have owners that are going to complain, well, wait a minute, that's a material alteration. That's not what it looked like before. You used a different substance,
Right.
Yeah.
Right. And there's one other one that was addressed right to me, but I don't want to answer it again. Don't have the ESQ. You're going to get sick of me saying that. It says, Jeff, where do the online votes end up? With the board or the management company? And I guess that would be a question more for our online voting providers, whoever has the administrative rights, or how would you answer something like that?
Ultimately, it's an association official record.
It's their call, right? Oh, okay.
Right. It's going to be, the platform is going to have all the results and everything, but obviously you're tabulating it at the meeting or however you're doing it, the manager or the attorney, or maybe a board member volunteer, depending on, again, how you're doing it and how you guys are operating, is going to have to see the results, at least the tally. And so
whoever they're designating, right? Whoever's designated to see the results, correct?
Right. Right.
And that's how it would be set up with the administrative rights in the platform. You're setting up who is allowed to see it. So that makes sense. Like any other techie platform, I would suppose. And anything else in there that looks alarming before I go over the any techie questions anybody might have?
Well, someone just made a reference to, or I see in here, there's a reference to documents that are not revitalized. And that's another thing. Again, I don't want to get into the nitty gritty of it, but if you are subject to 720, so this is HOAs only, there is something you should be aware of, and it's the Marketable Record Title Act, or MRTA. So you'll hear us say MRTA all the time, or MARTA, but MRTA. If your covenants are older than 30 years, they may have expired. That applies to HOAs and possibly their declaration. They have to either be preserved or they have to be revitalized if it's after the 30 years. So again, be aware of that. If you're talking about amending your governing documents and you're an HOA that's been around for a long time and you've never amended, you hopefully preserved. Otherwise, you're going to have to revitalize before you can even amend. So something to be aware of. And again, talk to your attorneys because that's a complicated process. It involves a membership vote before you could even amend. So something to be aware of.
All right. So what I'm going to do now is I'm going to turn it over to Lisa Rosenthal from ACE, and for both Lisa and for Emily to give final words, our thank yous and everything. And when Lisa and Emily are done with that, I'll stay on for another couple of minutes as usual to go over any technical questions, evaluation questions, and upcoming event questions. And I'll turn on the chat for that. But again, I'm turning on the chat just for questions of those types, not questions for Emily or for anything content related from today's webinar. So Lisa, our parting words for
Actually, I think
you and for Emily.
I'm going to let Emily, you share your final words, and then I'll just do some housekeeping. But I do want to thank you so much for all of your time, sharing your expertise. It's always so incredibly informative. You've always answered my questions, and I look forward to working with you again.
Thank you, Lisa. So nice to see you. I appreciate the opportunity to be here. It's great. I do love talking about this topic. It's a fun one for me because I get to talk about sort of lots of different things at the same time, which is fun. So I'm sorry. I know there were some other questions. We couldn't get to all of them. I apologize, guys. Some of them were very specific about your communities, so can't really get into them. Talk to your attorneys. If there's anything, obviously, we can help you out with, reach out. We're here. And thanks for coming today. Appreciate it.